How long have you known Shannon?
We went to school together.
Do you remember which school?
I know one of them.
Which one of them? Was it elementary or middle?
Might be elementary or middle, one of them.
And I know I just said his nickname is SB. Is that what you call him?
That's what I call him.
Shannon.
No,
Okay, what do you call Shannon?
I call him Shannon.
And do you see Shannon in the courtroom today?
Well, I got a vision problem. I
Okay.
can't see that far.
All right, so if you want to stand up and look around the courtroom and look around the entire courtroom, tell me if you see Shannon in the courtroom today. Do you need to sit down?
Nah, I can light here. I ain't had nothing to drink.
Okay, do you want some water?
You gonna give me a drink?
I'll get you some water.
I don't drink water.
Well, I don't have nothing else for you. But I will put some water up there for you.
Who am I looking for?
Shannon.
I think I see him.
Okay. When you say you think, you can have a seat. When you say you think you see him, what do you think he's wearing?
Look like he wearing gray over there.
So who are you pointing to over there that's wearing gray?
I think the lady got red hair.
Okay, so you pointing to a lady and not Shannon?
No, the one behind her.
Okay, so you believe that the person behind the lady with the red hair is Shannon. Is that what you're saying today?
Well, it looked like.
Okay. Does anybody else over there look like Shannon?
Yeah.
Okay, who's the other person who looks like Shannon over there?
He's standing behind the bald head dude right there.
He's standing or he's sitting?
Sitting down, I guess.
Okay. What's his hairstyle?
Bald head.
So you're saying Shannon's the one with the bald head? Or he's sitting behind
he's sitting
him?
behind the dude with the bald head. I think it's him.
Okay.
It's two people with dreads. I can't see I just see dreads.
Okay. Let me just ask you this. Is Shannon from Atlanta?
I don't know.
When you first met him, where did you meet him at? Was it in school?
Ooh.
While y'all were in school, did y'all develop a friendship?
Nope.
Okay. At some point in time, did you ever develop a friendship with Shannon?
Yeah.
Okay. When was that?
I don't know when, but at one point we became cool.
Okay. And when you say cool, what do you mean?
COOL.
I didn't ask you to spell it. I asked you what you mean.
Well, we became cool. I don't know what you mean. I don't know.
Did you look at him as a brother? Was he an acquaintance? Was he just someone you talked to on occasion? When you define cool, what was your relationship like with him?
Oh, just a dude in the street.
That's it? Did that develop over time?
Say that again.
You said he was just a dude in the street. Did that relationship develop over time? Where he became more than just a dude on the street?
I guess.
Okay. And when you say, I guess, what do you mean?
What you mean? What do I mean? We became cool.
Okay. During the course of your coolness with Shannon, did you meet any of his family members?
Say that again.
As your
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution and the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, he did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too, and the reason...
Well, I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, as Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have his... I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a party?
Yes.
A witness who was sworn in Friday? The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland...
Tell me how you got the information.
Listen, whatever you want to do...
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that, this court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was come from.
I don't want to be held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me who if you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas. And
Sir, you're straying off the issue.
I'm not.
The issue is, how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get for information?
But just listen to what I'm trying to tell you. You're saying,
the
threatening me with contempt.
privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break your order there, maybe. You're asking me, I'm not saying
you don't even know what he reading.
To give you information, and you're saying it's not substance, but I'm telling you I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going to breach that contract.
I don't want to hold you in contempt, but this is that serious,
Judge.
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking about?
But anyways, I'm not going to have
information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside our presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day.
But why?
Okay,
why
that's for another day.
In the first place? I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not when
That's real.
that is not the
That
case
was
when
real. That's really what it was.
somebody discloses
Oh my
information
God.
in a ex parte conversation that the one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been
probably
sworn.
really don't know what his shirt
You know,
says.
I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
The state wishes to be heard.
You said it supposedly, and what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the
Right?
transcript that you mentioned to be given to us so we can really understand it, and then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6, and I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we?
that leads to be told. But
Right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information because
Just
Mr.
stop.
Williams' constitutional right under
Just
the
stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1,
because
Section
you've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, madam, Ms. Love.
You got a task. You can do it, baby. You're doing it, baby. You're doing it.
And Your Honor, excuse me.
What?
And I know I said this
What are you talking about?
previously, yes, sir, but we are not accepting any proffer from this law.
Excuse me.
Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So, I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is, just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational, structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript, and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness, without us present, may have made the district attorneys and or Your Honor a witness to this in this case. a material witness in this case. And finally, Your Honor, I'm going to ask for, as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for. And also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations. But I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in.
Judge, don't trust him.
And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, are you same thing? You want the Harvey? Okay, all right. Okay, Mr. All right.
Good afternoon, Your Honor. Cards and that.
You guys have more business. All we do is sit in the fucking hallway.
Why are we here?
Right,
All right,
just
sir.
sit in the fucking hallway.
They're all going home and watching this film.
Duh. Wouldn't you?
Also, Your Honor, and when the court fees come out,
It would be hard not to. You would have to be like, oh, I'm not turning on the TV, I'm not turning on no fucking news, I'm not turning on no TikTok, I'm not turning on no social media. I'm just gonna fucking sit here and fucking read a book or some shit. Because everybody's talking about it, especially yesterday. Is it possible for you not to have seen yesterday? Right, and something told me to.
Everyone was proud of Steele for
again,
And I was like, the moment he was like, he stood up and was like, I think over there, or maybe that's him over there. He couldn't identify Shannon. I said, oh, everybody's gonna be talking about today. Everybody's gonna be talking about today. And then when Steele went to jail, I was like, oh shit, yeah, that.
All right, motion for
Then
mistrial denied.
then
Ms.
still
T.
fucking going to jail. Oh dang, I forgot to do that one. I forgot.
All right, thank you,
You
madam.
gonna give me a drink?
Motion's denied. Mr. Garner?
That means you need to give me a soda.
Right.
That's what he was saying.
Okay, so noted. All right. Okay,
Right.
Mr. Steele,
Apple
last time,
juice.
who told you?
Right.
All right, Mr. Steele's in
I forgot to
custody.
add that one in there.
And once he clears the area, no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Right. Think about that. Just terrible. Either he's a Bible thumper or he's a fucking one of these sharp ass people.
Your Honor, the court afforded me 1 moment to confer with counsel regarding the appropriate remedy for this testimony.
Okay, all right.
Get away from us.
He wants to be black and
Get it. Get it. Right in front of the. That was pathetic. Put it right there on his toy.
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I ask for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other one.
I've denied your motion, but I'll certainly take that under advisement, sir.
Too long. Can you put that in a sandwich bag or something? Yes, I'm gonna eat it.
We're going to be in recess for the next 5 minutes.
But it's with your goofy ass.